Before the final court trial, a preliminary trial or a case management conference is held. During this conference, only the judges and attorneys are present. The objective is to discuss the logistical procedures and the court setting that will take place on the day of the trial. This allows for both parties to review evidence, clarify points of confusion regarding the conduct of the trial, and other important matters. For example, a common discussion topic would be reviewing motions in limine, which are motions discussed outside the presence of juries to determine whether to exclude or admit evidence before it is offered at trial. Specifically, participants of this conference must discuss the following: the date and timings of the conference. Can the judges ask questions to witnesses? Does the judge allow the jury to take notes? Can jurors be allowed to submit questions to witnesses? What procedures must be followed to accomplish this action? Role of jurors and jury selection. Conduction of opening statements, direct examination, and cross-examination. How are verdicts decided? Will recess and sidebars be allowed? During the conference itself, including any recess or unplanned breaks, coaches, parents, and all other observers may not talk, signal, pass notes, or otherwise communicate with their teams. This also applies to team members not actively participating in the current mock trial. However, as long as it is not disruptive, communication between members of the same team is allowed. A recess can be called only in the event of an emergency, i.e., a health emergency and such. It is a breach of the rules for any witness to use notes or flashcards. While they will be allowed to proceed using them as to not harm their team's presentation, it will be viewed as an infraction and may result in point reduction. Other rules to follow are: be courteous and carry a professional attitude towards witnesses, other attorneys, the judge, and the evaluators. Rise when addressing the judge. Direct all remarks to the judge or witnesses. Don't make any objections unless you have a sound basis and are relatively sure the judge will agree. Be prepared to adjust to the rulings and preferences of the presiding judge, since they are the ones in charge.